In a recent development at the Western Cape High Court, a case involving 10 MK party members who are challenging their removals as parliamentarians sought an urgent interdict to prevent the party from replacing them after they were dismissed for allegedly lacking the necessary skills to serve as MPs. The 10 are part of a group of 18 members who were expelled last month, with some already replaced. The applicants are also seeking to halt further swearing in of new members by the National Assembly Speaker Toko Didiza until dismissal process are reviewed. To know more about this story, stay tuned. Welcome back to the Fraud News channel. I'm your host, Boss Robert. Thank you to those who have already subscribed to the Fraud News channel. I really appreciate your support. Thank you so much. To those who have not yet subscribed, please show your brother some love. Click the subscribe button now. Thank you. Back to the story. To summarize the proceedings of the case, we shall start with the respondent's strength, which is the MK party, and then we shall also discuss the applicant's challenges, which are the expelled 10 MK party members. The strength of the respondent's arguments. The respondent's counsel raised significant issues regarding the jurisdiction of the court, the urgency of the application, and the lack of procedural correctness by the applicants. The court seemed particularly concerned about the absence of MK party's constitution, which is a crucial document for determining the legality of the actions being contested. However, the respondent effectively argued that the applicants might not have a valid legal basis to seek the relief they were asking for, given the issues around their membership and the timing of the application. The respondent's counsel highlighted the procedural errors and the lack of supporting documentation from the applicants.
Good, thank you. Mr. Shitando?
As a floor, please. My ladyship, I believe we've got two sets of heads of argument.
Yes, that's correct.
The applicants will just deal with what I believe are the most important points within my heads of argument, and then stress the essentials regarding the terms that we need to satisfy the requirements of the interdict. And my heads do mention that if successful, the applicants would like to file a replying affidavit if an interim order is granted today and my ladyship is satisfied.
So you have to speak up, Mr. Shitando.
I said, my lady, if the court is satisfied and we do reach the threshold for an interim interdict this morning or today, the applicants would then be in a position to file a replying affidavit ahead of a...
But is the matter ripe for hearing if the replying affidavit hasn't been filed?
At this point, I believe it is. We can move, the applicants want to move on the basis of the papers that are before this court.
All right.
My lady, the respondents have, the first respondent disputes jurisdiction. Again, the second respondent, the Speaker of Parliament, has filed a notice to abide, and they have got no argument against the relief before your ladyship. The jurisdiction, the respondents are claiming that, look, the decisions that are before this court in the review application were made in Nkanda and not within the area of this court's jurisdiction. And the submissions that the applicant would like to make in that regard is that the MK party, like all other parties within the National Assembly, have a presence, have offices within this court's jurisdiction in the National Assembly. And those offices are within this court's jurisdiction, and on that basis, in terms of Section 2.1 of the Supreme Court's Act, this court does have jurisdiction to hear this matter. To the merits for, or at least the prima facie case for the review. The Speaker communicates on the 7th. I won't repeat what's said, but just it's important to state that she says she's received correspondence from the MK party saying that you're expelled from that party and therefore you're expelled from this National Assembly. That is, if you want to call it, the cause of complaint. That is why we're here, is that correspondence. Now, how did we get to that correspondence? That's the case for the prima facie relief that the applicants seek. And for that, I'm going to go into what the first respondent has said in their answering affidavit. I did say I'll concentrate on what's really important. What the first respondent says in their answering affidavit, which is the evidence, which was deposed by former President Zuma. For the sake of this argument, I'll refer to the former President Zuma. With no disrespect to the former president, it just makes it easier to argue. Zuma says that the MK party is a new party. He says it, and I want to quote, he says that it is his brainchild. That's what he says. And he says that his brainchild, MK party, has been governed by 3 phases. 3 phases governed this party. His words, the first respondent's words. The first phase ran from June to December 2023. The second phase ran from January to August 2024. And the current phase, the third phase, August onwards. But he doesn't give a specified date. He just says there shall be a Congress in the future. Those are the 3 phases. The second phase, and I suppose just following at this point, my lady, I'm at page 11 of my head. The second phase was governed by what Zuma calls the Interim Leadership Corps, the ILC. Now that is the most important phase, because it's the phase where the decisions that are subject to review were taken. It was during this ILC phase, if I call it, or second phase. And this phase, according to Zuma, and I quote, and I will refer to the exact paragraph shortly. The ILC, in its second phase, the phase in question, gave Zuma the powers to deploy all members of the MK party and sole discretion, at his sole discretion, until the democratically elected structures would be put in place. Implicitly, what he's saying, by saying, look, there will be a democratic phase later on, suggests that there is no democratic phase right now, on the respondent's own version. That's what he says. So he's got all the authority in the MK party from this ILC. How the ILC was created, the members of the ILC are not mentioned in the answering papers, but according to him, he has sole discretion. And that is paragraph 7.6 of the first respondent's affidavit. And just by the admissions that Zuma has made to all this discretion and the way it's pleaded in the answering papers, there is no consideration of the just administration, or the rights that the applicants have to just administrative action. None. He's saying that I am in charge. This is my brainchild. He can do what he pleases. Sole discretion is the word he used. The applicant's case is that, hold on, the MK party receives taxpayer money. We know that. We know that because they're in the National Assembly. I believe they're also in provincial, the provincial legislature, but in this case, the National Assembly. They also reside, the members of the MK who are in the National Assembly reside in state property. They are a political party, the third biggest party in this country. And the case that the applicant is saying is that you cannot behave in this manner. You cannot say that you can do whatever you like without consequence and without following the law, without following what the Constitution says about just administrative action. And Zuma's excuse is in page 12 of my heads of argument, and I'll quote him. There were serious political and security reasons for the decision, the finer details of which need not detain the court. Suffice to say that the space we operate is highly competitive, susceptible to infiltration and even politically motivated violence, which must be avoided and prevented at all costs. So that is paragraph 7.7 of the answering affidavit. My lady, those are the words of a dictator who says that there may be problems in governing this party democratically. And those problems are politically motivated violence, infiltration, and a highly competitive space. Those are the reasons why he says that he must not govern his party in a manner that is consistent with the right to just administrative action. That is his excuse. He then goes on to, in making his excuse for giving himself, or the IRC giving him the powers that he's mentioned he has, he says, and he accepts them, he admits the chaos in the MK party, he admits it. He says, given the historical messy process described above of clearing up the lists had not really been completed by the time that members of the National Assembly in particular had been sworn in. So he admits, he says that there was a mess before all of the members of the MK party were in Parliament. There was a mess for everyone, not just for the applicants. I obviously had no personal knowledge of all the 800 plus individuals on the lists, nor was it possible to verify their membership of the MK party since the membership system was not yet in full force, which is not completely up to scratch, although progress has been made. So he's making progress in finding out who the members of his party are. And he's saying that he does not know, and we'll go into that later, my leadership mentioned it, he does not know who the members of his own party are. And on that basis, my leader, just on that admission alone, it boggles the mind how the MK party is in any position to be appointing and removing anyone from National Assembly, where they admit to not knowing who their own party members are. Which is why a review application is important, and it is why an urgent interdict to stop this chaos from continuing to flow, the revolving door of National Assembly, where taxpayer money that goes to members of Parliament is exchanged in manners that do not follow any administrative process internally. And my ladies, also there is an allegation in the founding affidavit which is not challenged by the answering affidavit, where the correspondence to the speaker does speak to internal processes being made. The MK party said internal processes were followed, and that's part of the review application. The answering affidavit says that I don't need to follow any internal processes because I am in the second phase of my brainchild, this is Zuma, and he's saying that I don't need to follow any internal processes because the IRC is giving me sole discretion over this party, and that's it. And I did...
But Mr. Chitando, are you able to counter the argument that's put up in the answering affidavit that there was chaos reigning in which it was not clear who was a member of the party, it was not possible to verify membership, and that as a consequence of that there was a process that was undertaken and that the expulsions then followed, which included the 10 applicants, and that none of the applicants has put up any evidence to prove that they were a member of the party? That's the case. That's what's stated in the answering papers.
Sorry, Maddie, did I interrupt? I was going to answer.
No.
The answer to that question, my lady, and I'll get to that in... I'm trying to land the plane as it were, but quickly, the answer is that Mr. Zuma's own affidavit, he says he admits, and this is the most crucial admission that's so important to the applicant's case, is that he says that I expelled them. I expelled them. And the reasons, and I was going to go into how he's uncomplimentary to the applicants, but the reasons he sets out. He says that I expelled them. And the argument that the applicants are making is that you cannot say that we're never members of your party if you expelled us. You cannot come back and say, well, they don't have any evidence that they were ever members of my party. When he has said, look, I expelled you. You cannot be expelled from any party or any organization that you were never a member of to begin with. And that is obviously, when it comes to the evidentiary burdens that the applicants will have, that's something that's going to come up in the review application. What do we do?
But there's, of course, a counter-argument that an expulsion is of no force and effect if, in fact, one was never a member of the political party.
But, my lady, in this case, it's not the situation. In this case, it's not a hypothetical situation. This is a factual situation.
This takes me back to my earlier question. There's a factual dispute about, it seems, at some level, membership. And there's nothing really put up apart from a statement in the review papers that the applicants are members of the party. In the urgent application, it's simply not averred.
My lady, I'm going to get into what the test for the prima facie right and all of that later on. But what I'm coming back to, and the point I'm trying to persuade and move your ladyship on, is that the answering papers does not speak to, in regards to membership, a hypothetical situation. It speaks to a situation where there is an admission. My ladyship referred to Pascal Evans, the version of the respondent. There is an admission by Mr. Zuma who says, I have expelled you. You were in, he speaks to, I'm going to get into the quotes just now. He says that they don't have the skill set. He speaks to members of this party, not people, not arbitrary people or members of the South African public, not citizens that voted from the MK or citizens that are who believe in the message that he sells.
One's taking you to Pascal Evans not because that's the determiner for this application.
That's
it's
correct,
just that I'm dealing with that just simply to raise in motion proceedings these would be the problems. And here you've got to show that there's a prima facie right.
Yes.
And all the other requirements were interdictory really. And it was in that context that I raised it with you.
Yes,
it's just not clear where the prima facie right arises.
I'm getting to where it rises, my lady. But what we do know is that on that specific point, Mr. Zuma says that these are members of my party who are expelled, and he gives reasons. And I want to get into those reasons now. We cannot, and I can't put myself in your position, my lady. But what I would say is that it would be difficult for court to say, agree and say, well, look, they're not members of this party when the man who runs the party, who says it's his brainchild, who says that he's got the powers, all powers above all others in the party, he says that I expelled them, and I want to give the reasons now. My lady, going to those reasons. Mr. Zuma is uncomplimentary about his own party, who obviously, these members, the group of 10, this is how he describes them and other members. I'll quote him directly. In any event, some of the members, or some of the persons do not even possess the skill set, which is probably a reflection on our regrettable lack of time for screening prior to the submission of the lists. In any event, it fell on me to rectify those teething problems across the 7 legislatures in the country where the MKP has representation and nationally. So, my lady, just that admission alone, just if we were to unpack it, doesn't take too long to unpack what is said just in that one sentence or paragraph. He says that they had a regrettable lack of time for screening prior to submission of the lists. What they're referring to, the lists that the MK party put to National Assembly. That is the prima facie right. That's the smoking gun right there, amongst many.
Sorry, what is the prima facie right?
That is the prima facie right.
Is what?
Just what I'll repeat it, my lady. I apologize.
Is being on the list.
They say that there are members, they were on the lists. They had no prior time. They said, and I'll quote them, I don't want to put words in the former president's mouth. Regrettable lack of time for screening prior to the submission of the lists. The lists he's referring to are the lists that the MK party put before National Assembly to say, these are our people, and those people include the group of 10. And then he says what he did to them. And I'm going to go into more detail as we go through the version of the respondents. In any event, it fell on me to rectify, which is why we're here, is rectification. These teething problems across the 7 legislatures in the country where the MK has representation in national. Now I want to get into the decision. The decision that former president made in rectifying what he says is a problem within his party. In the exercise of my powers, and for various reasons detailed below, I determined that the applicants and others must lose their memberships of the MK party and in the National Assembly. That's Mr. Zuma's words. They're not the version, it's not the version of the applicants, it's the version of the first respondent. That admission is clear. It corroborates what the applicants say in paragraph 9 of the review application, that we are members of the MK party. Plascon Evans, this is what not that it's necessary here, but I'm going to, I'm going to get to Plascon Evans later when I talk about the test for prima facie relief. But the respondents corroborate. They say that he determined that they must lose their memberships. Not to lose memberships that they didn't have, memberships that they had. And that they should leave the National Assembly. So my lady would have picked up perhaps when my ladyship was going through the answering papers that there's an allegation made that the applicants who are not in the National Assembly properly. But what we do have here is the smoking gun, the admission that they were in the National Assembly by Zuma himself. He admits it, and he explains that they should be removed. That is the decision that is subject of the review application, which is married to this interdict. My lady, in this excuse, again, similar to what he said earlier in his answering affidavit, for these autocratic powers, I did mention dictatorship of his own party, because the IRC were not mentioned or specified in the answering papers, have given him all power to do as he likes. Zuma contends that the applicants have notably never challenged the lawfulness or constitutionality of the relevant protocols. In fact, no member of the MK has ever questioned or challenged the current interim dispensation. My lady, that is the excuse for these things. So he's saying that he's got a crisis and he's got all this sort of discretion to do whatever he pleases.
Now the respondent says, well, the review application is not good because it seems to be that you're arguing it as under PAJA, which doesn't apply, and that it's not clear on what basis you would have any right to, what the grounds on which the review are being sought in terms of what legal framework. That's their argument. That it's not a PAJA review, it can't be, and therefore it's not a legality review. What kind of review? It's not a common law review that this court would engage in, so what kind of review is it? And on that basis, they say there's no prima facie right to relief in an urgent application such as this, to obtain the interdict that you're seeking.
My lady, I'll get to the test for the prima facie right, but I would like to answer my ladyship's question. The review has been sought under Rule 53. Mm-hmm. That we know.
But that's a procedural. It's a procedural approach.
It's
to
a
any
procedural
review.
approach.
Doesn't matter on what basis the review is brought.
Yeah, but it's important that I mention the process, and I'll explain why. The respondents have to file they have a case in front of them, and they have to defend this review. They have to defend it. If a case has been brought against them, they have to defend this review. Because it's a Rule 53, they have to provide a record. They have to file a notice to oppose, which they still, to date, have not done. I was told by Judge Erasmus that the 2 files were going to be before my ladyship. I'm not sure if that is the case. Okay. There is no notice to oppose.
But I'm asking you a different question. I'm not asking you for the procedural issues.
I'm going to get to the merits of that review, in the limited way in which, in an interdict, an application for interim relief, that I can.
we'll begin with urgency, or rather I'll begin with urgency, Milady. Of course, that determines whether we can even delve into the grounds for incident. And we do say that it's not urgency. Milady, what we have before us are certain facts. And these are allegations that have been made out in the answering affidavit that have not been denied by any of the applicants, including the first applicant. On the 23rd of June, 5 letters terminating the membership of certain persons who were in MK were sent out. 2 of those letters were to the 6th and 9th respondents. That was the 23rd of June. Their membership was terminated. And a day afterwards, 12 others were also terminated. And the grounds for that, Milady, are also set out in the answering affidavit as to why their membership was terminated. I've also set that out in heads of arguments that appears from paragraph 6. And I'll mention some of them. It was because the names that had been added to the candidate list were either improperly or irregularly included, and the submission of names was made without proper consultation and vetting. There was a mishandling of the party list by the person who was responsible for that, and that was the previously acting Secretary General. Upon realizing this, that there was a mishandling of the party list, Milady, he was then replaced with Mr. Ngubane. And that is how they discovered with internal investigations that there were a number of persons who weren't supposed to have been on the party list to begin with. And the rest of those persons are the applicants to this application. Their membership was terminated on the 24th of June. How they came to be members of parliament or sworn in, as they state in their founding affidavit, Milady, is an anomaly because it means that they arrived there without the membership, the jurisdictional fact that allows them to be a member of parliament to begin with did not exist. It did not exist at that stage.
They were on the list.
They were on the list, Milady. However, by that time, their membership of the political party had been terminated. And on the list, it was for that reason as well that on the 5th of July, a supplemented list was delivered on the 5th of July to the National Assembly. Those are attached by the applicants, if I'm not mistaken. If I may just have 5 seconds for this one. It was attached in their review application. It appears from page 39 and I think to page 46. And in that list, that's dated the 5th of July, it includes all of the applicants, Milady, as members of the MK. However, their membership was either terminated or they had resigned from them. And again, the reasons for that are set out in the answering affidavit. The reasons for that have not been denied by the applicants. Milady, what we have is, and if it is so that the 2nd and 10th respondents had indeed given authority for the launching of the application, we have applicants before your ladyship who are trying to retain benefits that they were not entitled to in the first place by the time that they were sworn in, because their membership had already been terminated. Milady, this application was launched on the 20th of August, yes, following correspondence from the Speaker. But the termination of their membership had occurred 2 months prior. So urgent was the application that they had sought for the first and second respondents to file a notice to oppose on the same date and an answering affidavit on the same date at 4 o'clock for the matter to be heard on the 21st. Milady, it is our submission that this is one instance of entirely self-created urgency, and the purported rights that they seek to protect do not exist in the first place. On the points in limine, Milady, we have raised locus standi, non-joinder, and the jurisdiction of the court. And we begin with jurisdiction for one reason. The decisions that are challenged in the review application, which they say this part is pending on that. are with regards to the termination of their membership. The termination that occurred between the 23rd and 24th of June, 2 months ago, or 2 months prior to the launching of the application. And those decisions were made in KwaZulu-Natal. They were made in KZN, in Durban. Interestingly, my lady, the applicants also do not inform your ladyship when they left their jobs or the previous work that they had done, when they left their homes, which is presumably in KZN, seeing as their memberships were terminated before they were sworn in. My lady, that is our submission on the jurisdiction and the lack of jurisdiction for this court. With regard to the prima facie case which they have relied on is a paragraph in the review application with almost a general reflection on probably all the rights in the Constitution, including trade and, sorry my lady, if I may just go to it. It's paragraph 29, and it's page 29. They refer to the rights to administrative action, procedural fairness, equal protection, dignity to be respected and protected, freedom of association, political rights. But it doesn't speak to the rights in the institute that they are trying to protect.
Page 29 of the review application.
29 of the bundle.
In the
review application is 14 pages, really.
The review application, I was going to say, has nothing of something of no page 29. But it's incorporated by reference apparently into there's reference to it made. In the
reference to it, no quoting it, my lady. We do have certain rules when it comes to motion proceedings. You can't just make a bare allegation on your annexes. You have to refer to the parts that are relevant and which you're using in support of your case, my lady. Those are the principles that are applicable to motion proceedings.
The challenges with the applicant's argument. The applicant's counsel faced difficulties with the late filing of confirmatory affidavits and the overall management of the case, which the judge highlighted as problematic. The judge expressed concern over the lack of sufficient evidence and procedural issues, such as the missing of MK Party's constitution. The applicant's argument hinges on the interpretation of administrative justice and whether the actions taken by the party leader Jacob Zuma were lawful or not. However, without the constitution, their argument may lack the necessary foundation. This challenge was also apparent during the court proceedings, where the judge questioned the adequacy of the evidence presented by the applicant.
That the confirmatories don't make out a new case. There were personal circumstances which made it difficult to file those confirmatories timelessly, and that accounts for the delay in filing them.
My lady,
that you take issue with what Ms. Nyati stated, that the respondent has not received the affidavits. You say that they were filed and served and filed this morning.
Maria, I'm going to go into...
There's no proof, incidentally, in the court file that they have been served and filed. So
My lady, I've just received instruction. The confirmatory affidavit was served yesterday by email and were filed this morning. And the confirmatory affidavits, they don't just, when it comes to the dependents, my lady, the confirmatories don't raise the dependents for the first time, the fact that they're dependents. The founding affidavit does. And the respondent's answering affidavit responds to that. So there's no new case that's been made up by the confirmatory affidavit. It's a technicality to say, right, look, for the sake of technicality, we say that Mr. Khuzwayo speaks for us. And Mr. Khuzwayo said that our family members have been affected. That's not a new argument, my lady. It would be prejudicial to the applicants to say that, look, you have litigated this thing badly. Mr. Khuzwayo was the person they went to and said, you go and speak for us. And he did. He talked about the personal circumstances. He spoke, I think it's important I refer you to the paragraph where that is set out. I think it's paragraph 84 and 85 of the founding affidavit. No, 34 and 35. Page 30 of the bundle. The applicants were gainfully employed before they joined the National Assembly. They resigned from their jobs after they accepted the MK Party's nomination to the National Assembly. The respondents' administrative decisions have left all the applicants unemployed without any due process, in a manner that is inconsistent with our constitutional rights. Paragraph 35. The applicants are breadwinners and have dependents who include minor children left without financial support as a direct result of the respondents' administrative decisions. It follows that the respondents' decisions are not in the best interest of the affected children as provided for by Section 28 of the Constitution. My lady, you could not get more specific than that. That was not a case that was made out this morning. That was a case that was made out as we're speaking about detail on the 19th of August 2024. It's not new. It was not made out this morning.
But there weren't. The point is that there were not confirmatory affidavits.
There were no confirmatory
at that time, and therefore the respondent was within its rights to then respond, to answer to that allegation by saying what it did in its answering affidavit with regards to paragraph 34, in its response to paragraph 34 of the founding affidavit, and that is that I deny that the facts deposed to fall within the personal knowledge of the deponent and are true and correct, nor is he competent to make the legal submissions made. She ought to be rejected on that basis because there were no confirmatories.
My lady, that is a bare denial, first. And that answer does not dispute the fact that there are dependents. It's to deny that, adults have children and they put you to the proof.
But there are no specific details. This affidavit is so thin on fact. That's
My
the
lady,
difficulty.
we have an urgent application.
But urgent applications need work as well. You can't just file an urgent application of 11 pages without sufficient fact. For instance, you plead expressly that there's no constitution of the MK Party, and the answering affidavit states the contrary. There's no constitution placed before this court. The court's asked to determine an urgent application in respect of a matter which turns fundamentally on a constitution of a political party, and the constitution is not before the court.
My lady, I'm going to get into that point. I would like to go deal with one point at a time, and I think we're dealing with the confirmatory affidavits, not the constitution. I'll get to that. I want to go through the reply in the manner in which the Respondents' Council has set out their answer.
Proceed.
Right, but the confirmatory affidavit, my lady, that point, unfortunately, we're in a situation where the realities are, the facts are, that at paragraph 34 and 35, submissions were made and they are crystal clear to me. I've read them out. They say that the applicants are breadwinners. They quit their jobs to join National Assembly. They did that. And that was before the court on the 19th. This is an urgent application. We spoke of, and we have to look at everything in conjunction. We cannot look at the application in isolation. We know that the letter from the Speaker, I think that was the 19th of August as well. On the same day, they're communicating with the Speaker, saying that tomorrow, on the 20th of August, there will be no swearing in after the communication that took place. So this is the nature. This is what's going on. We've got one of the applicants that has come and he's speaking for everyone, and he has made out these submissions. Those are facts before this court. They're facts that we cannot close our eyes to. The confirmatory affidavits do not make out a different case from what the founding affidavit did. It doesn't. Now, my lady, what the detail that the confirmatory affidavit does go into, which is not in 34 and 35. My ladyship, you said that everything must be there. It's urgent, but still do everything. Okay, I'll deal with that point.
Well, the important
But,
material
here-
facts need to be there.
just-
In order to allow the other side, Mr. Chitando, if you were for the other side, in order to allow you a full and proper opportunity to answer.
Yeah, but I would not answer in that manner, and I'll tell you why, my lady. They've said that they've got dependents. What do the confirmatory affidavits do? They list the number of dependents. One says 3 kids, the other says 2, other says grandparents. But the most important thing is that they mention dependents that rely on them. That's the point that they've made to this court. And my lady, if I may land the plane.
But Mr. Chitando, the point that's made by your opponent is that there hasn't been an opportunity to answer to these allegations.
Okay, then, my lady, I want to
The
deal with that.
confirmatories are put up after the answering affidavit, and they contain facts to which, in respect of which, the respondent has not had an opportunity to answer. As a common practice, it wouldn't be permissible unless it was an ex parte application.
My lady, I want to say why I disagree with that. The confirmatory affidavits go, and I was saying this before my ladyship made this point. I'd like to make this point crystal clear, so we're all on the same page. The founding says that we've got dependents. The answer says you have not given us the exact number, or you haven't given us enough detail. It doesn't say the number. What the confirmatory affidavits do is they give the exact number. But my ladyship, my point is to this court, does it matter how many numbers? The point of the matter is the principle that their dependents who include minor children who are going to be left out. That is the point, my lady, that I'm trying to make. The fundamental point is,
I don't think there's any difference of opinion on that, Mr. Chitando. That you plead that they're dependents, and it may not matter. It may, in fact, have limited application to the matter. The point is just the practical point that the confirmatories contained information that wasn't put up prior to the filing of the answering affidavit.
Okay,
that's really the issue. And it may not be as big an issue as... it may not require the time that it's now taking to discuss it. The court can deal with it in its judgment, and it can deal with the timing of the filing of the replying affidavits.
But my ladyship mentioned how this affects, you in your address to me. You were saying that. Sorry, I apologize. I meant to say the respondent's address and your question on the respondents to me, the questions that on that issue. The confirmatory affidavit is you say that the manner in which the matter has been litigated. As I said before, it doesn't change, doesn't prejudice the respondents. It just says Mr. Khuzwayo speaks for us. And when he said that we've got dependents, he didn't say I have dependents. He said we have. That's what paragraph 34, 35 says. We have dependents. That was before the court on the 19th. Sorry, that was deposed on the 19th, and it was in urgent court when the matter was before Judge Erasmus. There's no new case.
All right, thank you. I've taken note of your point. Could we move then to the Constitution point?
My lady, if I may, I'll end up getting all jumbled up because I'm responding to the respondent's case, what she has set out, and I want to go in point form through what she has put out. So I've mentioned the confirmatory doesn't change anything. The suffering of the respondents say that the suffering that the applicant or the applicants have endured is not set out in the founding affidavit. That's what she said in her address. I've already said that paragraph 34 and 35 does set out the suffering that they've endured. Quite clearly, I cannot think of anything more difficult for a parent than to receive a minister's decision saying you're no longer part of a party, you're no longer in the National Assembly, and in days you need to leave. That's what they're saying there. What they're saying on paragraph 34 is quite clear. It's crystal on what the applicants have gone through. My lady, in regards to the manner in which the decisions are subject of review were made. A review application in terms of Rule 53.4 would then give the respondents an opportunity to oppose, which they have not yet done, and then set out the reasons for the decision that was made. The answering affidavit does provide some reasons, but the answering affidavit is inconsistent with itself. And that I've already gone through this morning of what Mr. Zuma is saying happened and what actually happened. He contradicts himself. He says they're members, but at the same time he says they were not members. Once the reasons are before the applicants, they can supplement their case. If Mr. Zuma keeps changing his case, they can supplement the founding affidavit in terms of Rule 53.4. They can amend as well, and then the nature of the review can change depending on what's in the record. Because what we have is a situation where the respondents are saying they were never members to begin with, but if they're members, I expelled them. They fortunately got onto the lists, and all of that. There's the disciplinary processes and procedures. That'll all be in the reasons, and then the applicants will be in a position to follow the rules of court and change their papers if the story of the respondents changes. In regards to the Constitution, my lady, the respondents do not refer to the Constitution, following the Constitution in the manner in which they expelled them. They don't refer to that. There's obvious confusion of what's going on in the MK party. They say there's the ILC, I believe, and not the Constitution gives Mr. Zuma the power. That's the evidence before this court. And the papers that the applicants and the respondents have put forward may not include the Constitution, but what's clearly taking place here is that there's confusion as to what constitutes the MK party. This is an unprecedented case, my lady. No one, Mr. Zuma is saying that no one besides him has the power to deploy or to remove anybody, with or without a constitution, draft constitution, existing constitution that was used just for the sake of getting this party registered with the IEC. The respondent's case, and we go to Plascon Evans, the respondent's case is that they didn't follow the Constitution. They say that Mr. Zuma didn't have to follow the Constitution. So whatever draft or, this is a chaotic situation that's been created by the MK party itself. But whatever governs the MK party on the respondent's version is not a constitution. It's an ILC. That's in the founding the answering affidavit. There is no constitution referred to by the respondents in their for justifying the expulsions in their evidence. And my lady, that's the version of the respondents, and we have to follow that version. Again, I think, my lady, if whatever document that the respondents come and say that this is the actual constitution, that can come out in terms of the record in the review. But where does that leave the intellect, my lady? I want to go back, if I may, to my heads. To be page 8 of my heads of argument. And I apologize if I sound repetitive, I just want to go back to the test. So I can satisfy this court that the applicants have met their test, irrespective of what argument the respondent's counsel has put forward. In an application
But I
for...
think it
I just want to... I'm not...
So if there's a point that you want to raise, that Ms. Nyati raised, that you want to respond to, that's the purpose of the response.
It is in response to that.
All right.
I'm responding with the test.
Well, you please don't restate it.
All right, I won't
Comment
restate the test. But my learned friend did say that, and I think even the answering affidavit says that there's a long laundry list. The word was used as laundry list, or two words were used, laundry list of constitutional rights. And we don't know what rights they're relying on. The prima facie case that has been put forward in the heads of argument is just administrative action and the lawfulness of that administrative action. That is what has brought the applicants to court.
That's the right you rely on.
But that's, I mean, it's a review, my lady. The applicants are reviewing and setting aside. And, my lady, Section 6.1 of Parliamentary, if we're to, this is something for the review application down the road. But Section 6.1 of Parliamentary does give any party the right to come to court and say that the lawfulness of the decision, we're questioning that. And it is very clear what the applicants have come for. They've come to set aside administrative action. The administrative action that Mr. Zuma has admitted to making. He has said that I have got the sole power, not the Constitution, the power to do what I like. Not the first phase, and I assume the first phase is this Constitution. I mean, that first phase, it's so confusing. But the first phase, he says that
without the Constitution, one wouldn't know what power that Mr. Zuma in fact would have. It's not before the court. I can't determine that issue.
But what the court does, what is before the court, is the fact that he is saying that he has got sole discretion.
But I don't know that because I don't know from the Constitution. Maybe the Constitution provides something like that. What must the court do when it's when it's faced with an application, an urgent application, which might be entirely meritorious, but in respect of which the fundamental documents required to determine the matter simply not placed timelessly before the court or at all?
My lady, we are at the interim interdict stage.
That's correct. Even at an interim interdict stage, Mr.
Yes,
Chitando.
but
the court can't willy-nilly grant court orders,
and we're
even
not
if
asking
they're of
the
an
court.
interim nature.
But we're not asking that. What we are saying is that, my lady, with the facts that are before this court, given the admissions that Mr. Zuma has made on how he's governing the party, and the people that are affected by his decisions, and when the review application runs the way that it's supposed to run in terms of the rules, could a court find? Right. There is doubt. I think Beecham does say that there could be, it's subject to doubt. I'm not trying to say that there's no doubt. That's at the interim interdict stage. That's not the burden that the applicants have to follow, have to meet. But with the admissions on how Mr. Zuma says he's governing the MK party, can the applicants succeed in setting aside those decisions? And the answer is yes, they could. When the review runs its course, my lady. And that is the argument that the applicants have made as prima facie rights. That is their case. The purpose of today's hearing is not to argue the entire review today, but to say, can they, with what Mr. Zuma has said about how he's conducting his party, and what the applicants have said about how they've been affected by the governance of his party, can we set aside the decisions that he's made? And the answer is, my lady, and I submit, yes, exceptional circumstances outer, and then I think I'll be concluded. Exceptional circumstances. My learned friend says that they're not there, and I say that they are. And the reasons why I say that they are is in the founding affidavit. I've already spoken, and I won't repeat. We're almost all done here. I already mentioned the dependents. That's at 34 and 35. So I won't burden the court with a repetition of the fact that these are applicants who are breadwinners and have been negatively affected by Mrs. Zuma's decisions. The exceptional circumstance, which is objective evidence, again, I won't repeat, the letter from the Speaker. Where she is saying that I'm going to replace you. You've been terminated, your positions have been terminated. However, they were terminated, it's got nothing to do with me, but I'll replace you. And then you will be left in that situation, replaced, without an interdict. And the review is then moot, and they've got no recourse whatsoever. They're then stuck in that situation of being roughly and rudely treated in the manner that they have. And whatever relief that they get in the review is pointless. In fact, at the review application, what will probably happen is the respondents would say that this matter is moot, the horse is bolted. We're now doing it's not an academic exercise of how Parliament should be regulated in the future. It have no practical force or effect, whatever judgment takes place at the review. That is an exceptional circumstance, given the positions that we're talking about, the seats in the National Assembly. There cannot be anything more exceptional than that. That's the reason why this matter has got the attention of the public. That is exceptional. The millions of people that voted for the MK party put their confidence, and Mr. Zuma says in his affidavit that millions of South Africans put their confidence in him, and then he has done this to the people that helped him get 53 seats in Parliament. And now we're talking about 10 of those 53. That is an exceptional circumstance. It's set out there in the paper. So, my lady, in response, there is exceptional circumstance. It's there by the nature of this application. My lady, that is, I think those are the points that, there's a note here. I'll just take one more instruction if there's another point. That is the case for the...
Do you have a draft order that you're seeking? Or are you seeking relief in terms of the notice of motion?
In terms of the notice of motion.
One to 1.1 to 7, I see. 1 to 7 of the notice of motion. Res 1 to 7 of the notice of motion.
That's correct.
Good. Thank you. I'm indebted to both counsel, heads of argument and argument today. Judgment is reserved and you'll be informed as soon as it's available.
As the court pleases.
Court adjourned.
In conclusion, to sum up the court proceeding, the respondent appears to have the upper hand based on the consent raised by the judge and the procedural weaknesses in the applicant's case. The applicant's case, while potentially strong on its merits, is undermined by its procedural issues and the lack of critical evidence. which the court will likely consider heavily in its decision-making process. Let me know what you think about this case by sharing your thoughts in the comment sections below. If you have enjoyed the video, please leave a like and subscribe to the Fraud News channel. Thank you for watching. See you on the next video. God bless you.